I'm the big man, attorney Joey Franks with Big Man Law here in Jackson, Mississippi. I got a little behind with the channel prepping for a jury trial that resolved after about 6 hours worth of motion hearings this Wednesday. And I wanted to get a video to y'all and let y'all be the judge again because this is fun stuff. We're going to Judge Middleton again. We've been on a roll with Judge Middleton. We're going to try mixing that up in Michigan, and this one is a rough case. Judge Middleton caught some flack on his ruling here, and I look forward to hearing what you have to think and how you would rule on this. And it's longer than our normal video, but well worth it. Hang around until the end to see how I would rule as a criminal defense lawyer and as a human being. But looking at the law, looking at the facts, see what I'd do if I was the judge.
So far for 2025, you win the prize for the most outrageous set of facts in a case. This is file 242277FY, People versus Michael Bryant Steele. He's here with his lawyer, Mr. Luke Knopfsinger. He was originally charged with larceny of building and assault and battery. He pled to 2 counts of assault and battery on the Walke family and also some of the staff at McDonald's. And the matter was set for sentencing here this morning. I'm glad the prosecutor's here. Frankly, I don't know what to do with this. I didn't order a pre-sentence. Maybe Mr. Knopfsinger can enlighten me, but something obviously was going on here. Above and beyond what is readily apparent. Mr. Gabriel, we'll start with you.
Your Honor, you're correct. As I reviewed the police report and more importantly, some of the information I've gotten from the victims, this appears unbelievably senseless. There clearly was something happening in this young man's head. I did note that in one of the victim statements, I think it was someone that worked with him, he said some pretty positive things about him and was hoping he'd get a second chance. However, as I reviewed the information I received from the Walkies, I don't know if he even understands that when he knocked the 72-year-old lady down, apparently pushed her once and knocked her down once, he ended up breaking her ribs. He ended up breaking the humerus off of her shoulder. This lady has undergone extensive medical procedures. She's going to physical therapy. It looks like somewhere in the area of $4,000 thus far is restitution that they're entitled to. There's some indication an insurance company might pay some of it, but they have no idea what or when. She has to undergo 10 weeks of physical therapy, and I think she's done 4 so far, and that's $30 out of their pocket. I was able to get the medical records. Fortunately, the husband in this matter, even though he was pushed to the ground and kicked several times and stomped in the chest, he didn't lose consciousness and he wasn't in any pain. Although obviously afterwards you can imagine he was in pain, but it doesn't appear that there were any fractures. So this young man really dodged a bullet in that I think a lot of this medical information was not known at the time the charges were issued. I reviewed the police report and it's kind of cursory that Milwaukee's one man was assaulted severely, didn't suffer any ongoing injuries, and that just indicates that Gloria was pushed and then knocked down. I don't think the office knew at that time the extent of her injuries, and clearly at a minimum it would have been an aggravated assault. The malicious destruction of the building, they're looking for $2,500 in restitution to restore the graphic and some damage to the drywall, but obviously the damage to the Walke family is much more severe than that. I also note that Mr. Knopfsinger did file a home useful trainee petition request I verified or indicated that our office didn't take any kind of position at the time. And in light of what happened here, Your Honor, and the fact that he's gonna have misdemeanors on his record, I certainly would oppose any further grant that allows him to escape responsibility for this behavior, no matter how long the court might put him on probation. I don't know how these people are ever going to recover their finances. I even indicated to the victim witness unit that they might need to talk to a civil attorney and look at where other parties might be liable. They were just customers going through the drive-through window. And it doesn't even appear that the defendant was working on that day, but for some reason he decided to go there and be a total fool. But a total fool that hurt people. And I think there has to be some responsibility imposed by the court for that behavior. Thank you.
I saw you at the time of the arraignment and the time of the plea, and you seem fine. There's a line in the police report. I attempted to interview Steele at the jail. However, he was too heavily under the influence of an unknown drug to fully understand. So I don't know what you did before you went back to McDonald's. Maybe you guys can enlighten me. What happened, Mr. Knopfsinger?
Yeah, Judge, a couple of things. I'll kind of start from the top because there is a lot going on here. I will tell you, tell the court about kind of some of the things that he has done since. He lives with his mother, who's in the gallery today, Miss Brown, who's very supportive. Since that time, he has gone and he got a pivotal appointment. There was a kind of a timing issue. So that initial intake had to then be lopped over to the 15th. So they'll continue to do that. He did go across the street, Judge, and get involved with Covered Bridge. He has some therapy that he's going to, and then a psychiatrist maybe to help with some of these issues. So that's very good. I will go back to talk a little bit about what happened that day. This was Mr. Steele's 18th birthday. I think there was even a question whether or not, because that was his birthday, whether or not this was a juvenile matter or it was an adult criminal matter. And it's very clearly, and I think this is the only one I've ever had, was the Ida statute says on or after the defendant's 18th birthday. And this was, in fact, on his 18th birthday. It was a Saturday. And since that happened, he was arrested that night. He spent 17 days in jail until this court gave him a bond after he'd entered his plea at the preliminary exam conference. And having spoken to his mom, she went in and she had contact with him while he was in jail. He was acting a little bizarrely. There were times where he was in the restraint chair. And some of the things that he had said to his mother over the jail phone were very suspicious to her. They were odd. They were didn't seem to align with how he had acted before. It was the first time he'd ever been in jail. She then went in and sort of raided his room there and found bottles of Robitussin, some other drugs. And having spoken to him too, there's a lack of memory too in terms of what exactly happened that day. So I do think he was under the influence, explains some of that behavior. Doesn't justify it, but it explains some of it. At some point too, I think even some of his coworkers were kind of startled by the conduct. They were interviewed and tried to calm him down, and he didn't seem reachable. Went over the restitution figure. We're stipulating to the $2,500 for that to be for the entryway to be repaired, whatever needs to be done. Did just receive the figures this morning. We're stipulating we're not going to object to any of the restitution. Honestly, I get a little reluctant doing that, knowing that there could be more in the future as well. but I don't get any sense from my client that he's reluctant to be held accountable for the restitution. So we're comfortable doing that. We would ask the court, and I can understand that this would be quite an ask to be placed on Home's Youthful Training Act. Along with that, we will be asking the court to impose kind of conditions above and beyond. He is going to link learning. He's a little behind talking to the administrator whether or not they will sort of move to the next semester to avoid losing some credits and some other things. In terms of employment, him and his mother waiting to see what would happen today. Limited because it's a one vehicle home. And so transportation will be an issue because his mother works full time. The short of the long, Judge, if the court wanted to impose those conditions on him, I'm hopeful he can comply with those. The other is that compliance with any substance abuse therapy. It's very likely that when he completes this pivotal intake on the 15th, that substance abuse therapy will be recommended in addition to the therapy that he's doing there at Covered Bridge. There may be some attention issues as well, which I think the psychiatrist at Covered Bridge can really help him with. He is a young man. When I went to visit him for the first time at the jail, Judge, he was, kind of taken aback, embarrassed, and I think most importantly, remorseful for what happened. He had no idea that these two elderly people had suffered broken ribs. I think, and that was kind of telling for me. And quite frankly, he was a little, even a week later after the incident, he didn't really, having met with him since, I realized that wasn't really him when I went and visited him. So when I started to suspect the drug involvement. Had several conversations with his mom. I think this is a wake-up call for him. It's the first time he's ever been in jail. So for that, we would be asking the court to consider the Home's Youthful Act.
Mr. Steele, is there anything you want to say to me?
I have a restraining order on the two.
Let me ask you this. Do you remember what you took? What set you off on your 18th birthday like this?
I do say that.
What did you take?
It was a bottle of Robitussin.
All right. Just one?
I believe I took 4 prior to that day, and it kind of just stayed in my system.
5 bottles of Robitussin. Anything else?
And then I tried to overdose on Benadryl as well, which did.
How much Benadryl did you take? Liquid or Benadryl pills?
Pills, I don't know. The most I've ever done though was like 20, 30 pills.
So you've done this before?
Yes, sir.
All right. Did you watch the video of what happened?
No, sir.
Well, it ain't good. The video shows a clear picture of what happened, which perfectly aligns with the victim's statements. Steele was seen walking into the McDonald's. He walks into the kitchen and speaks with several workers. He then pours a drink onto Larry Walke through the drive-through window. Steele confronts employee Draper and shoves something in her shirt and shoves her. He then grabs a large bag of food and attempts to flee out the east exit. Steele is met by Larry Walke at the door because he's like, hey, this kid just poured a drink all over me in my car. And Steele attacks Walke. Steele throws Walke's face first into the wall, causing a face-sized hole in the wall. Walke slumps to the ground and is able to get up, either from injury or age. He's about my age. Steele speaks to Gloria Walke and then runs around the building. He re-enters the building and jumps over the counter, re-entering the kitchen. He shoves Roman, one of the McDonald's employees, and grabs some more food, and again tries to flee out the east exit. He shoves Gloria Walke. Larry Walke grabs Steele, and Steele slams his foot on Larry Walke's chest. He then shoves Gloria Walke out the door and onto the concrete outside. He then shoves Rosado, hugs her, enters the building a third time, knocks stuff down in the kitchen, grabs more food, then climbs through the drive-through window and flees. It's like reading about the Tasmanian devil from a Warner Brothers cartoon. I'm not giving you Holmes youthful trainee status. This all happened quickly from the prosecutor status. I guess we can review it because I'm going to put you on probation because you got a lot of money to pay. But they didn't realize at the time they made this charge and then the plea offer, the extent of the injuries to the Walkies. Prosecutor Marvin and Andrew Rogas were still in the office when this happened in December, just before Christmas. And I arraigned you before the end of the year. And then I took your plea in January and I let you out of jail.
Sir,
Yes?
I was going to ask if I had a restraining order because I don't know how I can apologize to them. I would like to.
You can write a letter to the prosecutor's office or to your lawyer, and he can share it with the prosecutor and the victim advocate to share it with the Walkies. I'm not sure they're very charitable toward you. Now, you weren't actually working. You were a McDonald's employee. Mr. Gabriel was sort of diplomatic about it, but there could be a possible cause of action against McDonald's. This is just terrible. The law used to be that you were an adult for criminal purposes at midnight on your 17th birthday. We had at least 2 young men here in St. Joseph County that were killed or were convicted of homicide while they were 17. One boy killed both of his parents on his 17th birthday, almost 45 years ago. He's still in prison. They changed the law a couple of years ago, and now you're not an adult in Michigan until midnight on your 18th birthday. This was the evening of your 18th birthday. Not a very good way to celebrate it. If one of these people had died, heaven forbid, you'd be looking at some sort of manslaughter charge. And I do believe you that you don't have a clear memory of this, but it doesn't make it any less serious. I'm going to do 24 months probation. No drugs and no alcohol. Test as directed. Cooperate with Pivotal. Cover bridge. Sign a release. You're going to stop goofing around with your education. You're either going to get a diploma or a GED, or I'm going to revoke your probation. Time to do this is now.
Yes, sir.
Call that dragging people over the finish line. restitution of 2,500 to McDonald's. Fine is $0. There's a $75 crime victims' rights fee and a $50 state minimum fee. I'm gonna put a $960 probation oversight fee. You may be on probation for the whole 2 years. No HIDA at this time. I suppose if you do an outstanding job on probation, prosecutor may reconsider.
Will court reserve restitution to the walkies?
I'm gonna do it on the other judgment.
Okay.
I did one assault and battery and then a second assault and battery. One for Mrs. Walke and one for Mr. Walke. In the first assault and battery, I'm ordered 17 days, credit 17 days. Giving 0 to serve. Right now, they're not taking weekend cases at the jail, and I let you out after 17 days. You got 93 days hung over your head. If you don't comply with the terms of this probation, you might as well just figure you're gonna do the balance of 93 days.
Yes, sir.
Mayor, might I suggest, in light of what the court said, having gone to the University of Michigan 40-some years ago and finding myself in a similar situation, and the condition of his probation be that the probation officer show him and let him see the video at McDonald's?
Yeah, I've done that before. I had a drinking driving case where I had the view McDonald, view video. No contact with the Walkies or McDonald's.
All right, let's recap our facts here. This guy, he's an employee or former employee, I would assume by now, of McDonald's, and he ends up knocking down this 72-year-old woman, breaks multiple bones, hurts her shoulder. They're talking about there's only $4,000 worth of medicals. I've done enough personal injury to tell you there's a hell of a lot more than $4,000 involved in just about any broken bone. So something's not adding up there. They're talking about restitution and insurance may pay some. In Mississippi, we have something that's called the collateral source rule. So this guy wouldn't get to take advantage of it, essentially, is the argument here. And it was one that, in the motion hearings that I just did, came up in a criminal matter, and Mississippi actually hasn't addressed the collateral source rule in criminal matters, so that was fun. But there's a really good argument that this woman and her husband, they paid for their own insurance. He doesn't get the benefit of it. So if they incur $10,000, or in this case $4,000 worth of medical bills, and insurance pays all of it but $1,000, he doesn't get the benefit of what insurance paid. He certainly wouldn't get that in the civil side of things, but there are arguments to be made on the criminal side. But it's a fun little fact that I actually just dealt with, so I thought I'd tell you all about it. Now, he knocks the husband down after slamming his face into a wall. They said eventually that it left a face-sized hole in the wall and then stomped the guy on the chest. Didn't break any bones, but this is crazy. They said the extent of the medical information wasn't known at the time of the police report, and the damage to the drywall's $2,500. Who cares about the drywall, to be honest, in this scenario? But I get it. As a prosecutor, I would certainly bring it up, so I understand them bringing it up. The defendant is smart in the sense that he is stipulating to restitution. He's got some linked learning things, substance abuse therapy, first time in jail. They're bringing all this stuff up, and I get it. I'm on that side quite a bit. But before I get to it, how would you rule? I was about to let the cat out of the bag. I'll give you a second here. All right, so you've put your rulings in the comments, your thoughts, your opinions. Judge Middleton puts the guy on probation. Says you served 3 days, we're gonna give you 93 days over your head. He said they didn't realize the extent of the injuries when the plea deal was made. Blows my mind. Unreal. From a criminal defense perspective, this guy just got the deal of the century. I could not imagine a Mississippi court where a judge would approve this deal. Just can't do it. Now, from a human being's perspective, I actually detest this ruling by Judge Middleton. I normally like his rulings. I'm normally someone that thinks, yeah, we should be a little bit lenient on folks. You know, they got to take the medicine when they got to take their medicine. But at the same time, you can't just leave folks out hanging out to dry. But you got to do something. This is about as egregious as it gets. This should be felony level. Frankly, I'd probably sentence him to the full 96 days in jail and let him stay there. And then when he come out, he could go deal with all this other stuff. And this is pretty rough. So they're talking about they didn't realize the extent when they made the deals, yada, yada, yada. None of that really matters, because here's what happens. The prosecution can change their mind and say, I don't want to give you that deal, and go yank it. And away you go. You go to trial, have your day in court. They have every right to do that. What's more, if you read any plea documents in the state of Mississippi, they all make it clear that a judge isn't bound by this plea deal. You're pleading guilty, and you can be sentenced just like a jury found you guilty. And there may not be a jury in here, but the concept is exactly the same. So Judge Middleton should not have gotten on board on this. I damn sure wouldn't have gotten on board with this. And I'm a criminal defense attorney, and I'm all about giving folks the benefit of the doubt and things like that. This guy avoided 2 felonies is the way I look at it. And frankly, they should hang him out to dry as much as they can in the county, at the county level. I say the county level, it'd be the justice court here in Mississippi, or the municipal court. In any event, he should pay the full freight on these misdemeanors. No ifs, no ands, no buts. Getting drug help and getting your GED, are you kidding me? That stuff you should already be doing. If you want to get better, be a productive member of society, you've got to have some basic education, and you clearly can't be strung out on drugs. So that's my thoughts. I normally love Judge Middleton. I really don't like this ruling at all. So based on that, that's what I think. And I don't think it would stand in any court in Mississippi, not even the most lenient ones. I've had a great time. Hope you did. I look forward to hearing your opinions, seeing. It'd be really cool if you could make it to where I could hear them. But in any event, hope you have a great time. I sure did. And I look forward to seeing you on the next one.